Welcome everyone to our webinar on Mastering Trademark Use, Tips to Protecting Your Brand with IP Australia. My name is Rebecca Jones and I am the Trademarks Practice Group Leader at LegalVision. I'm very grateful to be joined today by my co-host Adrian Richards, who is the Supervising Hearing Officer in the Trademarks and Designs Group at IP Australia. By way of context for our viewers, IP Australia is the government department responsible for the registration of IP rights and the administration of IP legislation in Australia. From a trademarks perspective, this means that everything to do with trademark registration is done by or with IP Australia, including applications to register trademarks, examination of trademark applications, and hearing of trademark oppositions. Although we work quite closely together, the roles of LegalVision's trademarks team and IP Australia in these processes are quite different. IP Australia is an impartial government entity that facilitates and examines trademark applications and oppositions. On the other hand, LegalVision's trademarks team represents trademark applicants and opponents in various applications and proceedings before IP Australia. I think our viewers will find it very insightful to hear from both perspectives. Now, before we begin, a couple of quick housekeeping items. You'll receive the recording and slides for this webinar in your email. Please submit your questions in the Q&A box throughout the webinar and we'll answer them at the end. And please take a moment to complete the feedback survey after the webinar. For the next 48 hours, you're eligible for a free consultation with LegalVision to discuss how we can help your business. To take advantage of this offer, please provide your contact details in the survey at the end of the webinar. Okay, so today we will be discussing all things trademark use, including what trademark use is and why this concept is important, steps you should take before using a new trademark, and this will include a demo of IP Australia's very useful TM Checker tool. We'll give you some tips on how to ensure your trademark is used correctly and without inadvertently eroding your rights. We'll explain how evidence of use of a trademark can be relied on in trademark examination and opposition proceedings before IP Australia. And finally, we'll look at the consequences of not using a registered trademark. And at the end of the webinar, we'll be answering some of your questions. Okay, so to start us off, let's look at exactly what we mean when we refer to trademark use and why this concept is important. Firstly, what is a trademark? Well, a trademark is defined in the Trademarks Act as a sign that is used or intended to be used to distinguish goods or services dealt with or provided in the course of trade by a person from the goods or services so dealt with or provided by any other person. Basically, does the sign that you are using or proposing to use serve the purpose of enabling consumers to differentiate between your goods or services and those of your competitors? The most common trademarks are words or names and logos, but a trademark can consist of a wide variety of different types of signs, including colors, such as Cadbury's color purple, and sounds, such as Nokia's classic ringtone. Both of these are registered trademarks for their respective goods. It's important to understand that not any name or sign that you use to refer to your goods or services will be recognized as a trademark. For example, descriptive or generic terms are not trademarks. To determine whether the sign is in fact a trademark, ask yourself, is it capable of functioning as a badge of origin for your goods or services? As an example, if I see soft drinks for sale under the respective signs Coca-Cola and Pepsi, I'm readily able to identify the differences in the origin of each product because the trademarks function as badges of origin. By comparison, if a mechanic based in Sydney is referring to their services by using the term Sydney mechanic, that's descriptive or generic use and is not trademark use. It doesn't help me as a consumer distinguish between the business's services and any other Sydney mechanic services. Now, in terms of the trademark protection framework in Australia, the best trademark protection available is that of a trademark that has been registered with IP Australia. A registered trademark is protected under the Trademarks Act, which gives the owner exclusive rights to use the trademark, to authorize the use of the trademark by others, and to take legal action against parties who make unauthorised use of the trademark, which is known as trademark infringement. A trademark can also be unregistered. It's actually a common misconception that a trademark is synonymous with a trademark registration. In fact, a trademark can exist as soon as you create it or use it, and before you even apply to register it with IP Australia. It's not mandatory to register your trademarks in Australia, but unregistered trademarks do not have the same protection provided under the Trademarks Act and can be more difficult to enforce. You would generally need to rely on the misleading and deceptive conduct provisions of the Australian consumer law or the common law tort of passing off to enforce an unregistered trademark. So now that we've laid that groundwork, what is the significance of trademark use and why is it an important concept to understand? There are plenty of different situations where trademark use is relevant to your IP rights and potential risks involved in running your business. For example, is there some aspect of your branding that might infringe someone else's trademark and cause legal problems for you? If you become aware of a competitor using a similar name, it is important to know whether it is really trademark use or if it is perhaps descriptive use and whether there is anything you can do about it. You also want to know whether your use of your trademark is within the scope of your trademark registration and therefore protected from action by third parties. And another thing to think about is whether your trademark registration is potentially vulnerable to removal for non-use. If you encounter obstacles during the examination of an application to register your trademark with IP Australia, can you rely on your use to overcome those obstacles? And similarly, can your use of your trademark be relied on to successfully oppose someone else's application to register a similar trademark? If you are authorizing others to use your trademark, are you adequately protecting your rights? There's so many things to think about. And as you can see, trademark use is a really important concept that touches on all of these things that I've just touched on. And is something to be well aware of in your business activities. To get you started with some practical tips, Adrian will now run through some steps to take before you start using a new trademark. Over to you, Adrian.
Thanks, Rebecca. So look, my first tip, if you haven't already got a trademark that you've got to deal with, if you're thinking up a new one, take some time to do that and think of something that's both easy to remember and has nothing, we recommend nothing to do at all with the goods or services you offer, or where you're based or anything like that. I mean, I can imagine that to most sort of traders, memorability is obvious. You want people to be able to remember your business or your products you're offering. But why shouldn't it relate to your goods and services? I mean, you want to tell your customers what they do, right? What they are. Well, it's because other traders are likely to just try and step into that space, and you'll end up in a lot of fights that you probably don't need to have. So there's a really good example from, it's about 5 years ago now. Might be even older, but it's worth having a look at if you just sort of do a search for man with a van. You can search man with a van IP Australia because I think we're mentioned in the news articles. It was a great idea, but lots of people naturally thought of the same cute little phrase, and it made that person's life quite hard. So once you've actually got a nice unique sign, then you want to move on to clearance searching. So this is to make sure you're not intruding on others' existing rights. So filing with IP Australia, you will be automatically seeking national coverage, all of Australia. You might know your local market, but there may be others in far-flung locations and you really need to search for these. Not all trademarks are registered, as Rebecca mentioned. So you really need to perform general searches for key elements of your chosen sign via things like generalist search engines or looking in industry periodicals. This is a really tough area of work, and it may be worth outsourcing to a registered trademarks attorney who do clearance searches for a living. The other type of searching is to look for marks filed with IP Australia. The reason for this is because they technically don't have to be used in order to stand in your way in certain situations. We have a standard search tool that we use in-house. Well, it's a modified version for the public, but it's called ATMS. Again, trademark attorneys, professionals in this area are well versed in its use. We do have guides online on how to get the most out of it, but it is a kind of a specialized tool. And we recognize that it's a bit difficult to use. So we've developed a simplified search tool, and it doubles as a rough and ready guide for whether your chosen sign is likely to pass examination. It's called TM Checker. You can find it by just searching for TM Checker. Our search engine optimization is working pretty well. We're running this a bit funny. Rebecca's going to try and show you how this works while I talk. So I'll just pause to make sure we're all on the same page.
Here we go. So if we look up TM Checker on Google, you're right, first listing. Very easy to find. We'll click in here.
Yeah, you have to start, and then I think you have to read all the warnings. There's similar warnings to what both Rebecca and I have talked about just now, and then OK. Now I'm going to ask Rebecca just to be a bit cute and search for LegalVisual. That's fine. I think that's what we wanted, wasn't it?
Yes.
So our hosts, LegalVision, may be interested in the results here.
So before we get to this point, I'll just point out you can choose here to either search by a word or phrase in plain text or a logo. For this one, we're going via the word or phrase. So I'll click next here.
And then we're going to look for legal advice services. That'll do.
Here we go. And you can see as you scroll down here, there's different classes of goods and services that you might be looking for. So it's a really handy tool to help you, see what's out there in different classes and determine the scope that you're looking at. So I'll click next here.
And that's slightly different to what we were yesterday. But anyway, let's have a look at the similarity results first, if that's okay. I'm curious about what's up above, actually. There we are. LegalVision does show up there a couple of times at least. So we can see that, our hosts know their stuff here. But also, I mean, this is really just to serve as a quick warning. If you want to file as LegalVisual, you're probably going to face objections around these trademarks being too similar to yours. I might skip the distinctiveness thing here, and we'll go for something really, really clearly distinctive. So, Rebecca, if you could change the search to the law firm, please.
Yeah. So I'll just click on Edit Trademark here. Change to the law firm. Next.
We'll go with the same services, of course. And we'll have a look at the distinctiveness issue now. If that's, yeah. So, I mean, it's just a general guidance, and there's a little video to play, but essentially this is raising the issue of, the law firm for legal services. That's the kind of thing that other people are going to want to use pretty naturally. So yeah, it's just a nice little tool to sort of do a little bit of help if you're brainstorming, I guess. You can use it for free as much as you want. So, and I think if you settle on a good like mark and goods, you can just feed through into actually applying through the tool. So it's it's right there. So yeah, handy little tool. Anyway, I'll move on though. So the next step before using a new trademark for a lot of traders is to seek registration and even obtain registration. It's not necessary, but a lot of people do it just for the extra protection. So there are a lot of advantages to filing with IPA. In the sort of audition of this, or the run through of this, I rattled on quite a while on this, so I'll cut it shorter. But essentially, it makes dealing with the mark simpler. So if you need to sell the trademark later, for example, it's a lot easier. It also you get rights instantly. You don't have to start using the mark to get the right to exclude others from using the term. So it's kind of useful. Also, probably the one thing I think is going to be really interesting to small businesses in particular is if you want to expand, or if you think you're likely to expand your business in the future, as long as you intend to do so, you can actually apply for a broader specification of goods and services than you're currently using, provided you get into actually using it within a certain amount of time. And we'll talk a bit more about that amount of time later. Is there anything else to say here? I think that's it for now. I'll hand back to Rebecca.
Thanks, Adrian. Okay, so now let's look at some tips for ensuring that you make correct use of your trademark so that your use is protected and that your rights aren't inadvertently eroded. First of all, think about the scope of your use. Your trademark use is protected across the range of goods and services you have registered it for. If you want to expand into a new product or service category, review your protection to see if you're covered for those new offerings. If you use your trademark outside of your range of registered goods and services, you may inadvertently infringe another person's trademark, and you may not be able to rely on your registration to protect you against legal action. If needed, you can expand your trademark registration portfolio to protect your wider range of goods and services by filing additional applications. It's also important to remember that trademark rights operate on a country-by-country basis. So an Australian trademark registration only protects your use of the trademark in the Australian market. If you're providing goods and services in overseas markets, you'll want to look at international trademark protection as well. It's also important to be mindful of the manner of use of your trademark. If you use the trademark exactly the way you have registered it, this will ensure that your use is protected and also that your registration doesn't become vulnerable to removal for non-use. Minor variations to the way you use your trademark compared to how it's registered are generally acceptable, but substantial changes may affect your rights. If your branding changes, you'll want to revisit your protection. So look at registering any new logos or any sub-brands that you develop for different product ranges and so on. It's also important to avoid using the mark as a noun or a verb. Best practice is to use it as an adjective followed by the descriptive or generic term for the item. Now, this will avoid the trademark itself from becoming known as the generic term for a product, which can result in you losing your exclusive rights. So if your trademark was, for example, escalator, you would use it in the context of referring to the escalator moving staircase. Escalator is just one of many examples of terms that were once exclusive trademarks but have now been lost to genericism. And there are countless other examples. We've got aspirin, we've got jacuzzi, Band-Aid, cellophane. All of these were once brand names that are now considered to be generic product names in a number of countries. Also, it's important to know when to use the TM symbol or the R symbol. The TM symbol stands for trademark, and this can be used alongside your trademark as soon as you start using it. You don't need to have filed an application to register it yet. The R symbol, on the other hand, stands for registered, and you need to be a lot more careful with your use of this one. It can only be used once your trademark has been successfully registered with IP Australia. If you use this symbol alongside an unregistered trademark, that's actually an offence under the Trademarks Act, so something that you'll want to avoid doing. Now, let's look at authorised use and control of a trademark. You want to ensure that the registered owner is either using the trademark or authorising the use of the trademark. This ensures that the use is protected by the registration and also that the registered owner is not inadvertently eroding their rights. If you, as the trademark owner, are allowing another party to use your trademark, for example, by way of a license, you'll want to make sure that such use constitutes what's known as authorised use under the control of the registered owner. Under the Trademarks Act, authorised use requires that the registered owner of the trademark either A, exercises financial control over the relevant trading activities of the licensee, or B, exercises quality control over the goods and services provided under the trademark by the licensee. So for it to be authorised use, you'll need to meet one of those tests. Finally, if you become aware of an unauthorized or uncontrolled use of your trademark, you should take swift action to stop this. Unauthorized use that goes left unchecked can result in the loss or dilution of your valuable trademark rights. Now, Adrian will explain how trademark use can be relied on as evidence in examination and opposition proceedings with IP Australia. Thanks, Adrian.
Rebecca. Yeah, I'll start with examination. Look, evidence, it can be a really important tool for overcoming what we call objections raised by our examiners. There are two areas in which evidence is frequently required and furnished at examination, and that's in relation to distinctiveness and similarity objections. I'll start with the distinctiveness objections, and again, they divide generally into two categories, and that's strong and weak. These are my terms, by the way. This is not in the law. So look, we'll start with strong there. So if you followed, the warnings that we've been offering and TM Checker earlier, you probably won't have a problem with distinctiveness. But in case you ignore it, or in case you have a mark that's, well, it really what it's for is if you have a mark that might trigger this distinctiveness objection, but you've been using it for a very long time, you will face the objection, and here's how you kind of have to get around it. Effectively, what you need to do is convince the examiner that even though you've decided to call yourself Sydney Mechanics, to borrow Rebecca's example, that doesn't matter, because everybody in Sydney, at least, and the country generally, when they hear that term, they think of you. They don't think of the descriptive words. I.e. that it's come to have another meaning in fact. So it can be a hard thing to do. That's why it's a strong objection. And obviously, you need to have been using the mark from before filing to be able to show us this evidence. The weaker objection it's a funny one. Australia's kind of on our own here, almost, in the world in terms of having this. But essentially, what we're saying is, look, it's kind of descriptive, but it's not. The bits that make it not descriptive aren't strong enough to really distinguish you from other traders. An okay example of that is probably like the honeycomb and chocolate bar Crunchy, spelled IE at the end. This thing is crunchy. So it's a really clear description of an aspect of the thing, what it does, but the misspelling lifts it from that strong objection into a weaker one. In that kind of situation, you're actually allowed to put on evidence of the same prior use if you want, like you could with the strong objection, but you can also put on evidence of your plans to use it into the future, and evidence of use after your filing. So we can take more into account, and really the question that the examiner is going to need to be convinced of here is that even though it may not be enough now, because of the use you plan to put it to, it's likely in the future to gather that characteristic of being, people identify it with you and not with others. Yeah. Okay. The other big area is similarity. So going back to my example of LegalVision earlier. So we know there are several LegalVision trademarks registered. How do we get around that using evidence of use? Well, there are other ways, of course. You can convince the examiner that they're sufficiently different, for example, but I think you might be struggling with LegalVision versus LegalVision. Anyway, in terms of evidence options, they're highly situational. Broadly speaking, there are three categories where evidence can be provided: prior and continuous use, honest concurrent use, and other circumstances. Prior and continuous use is the simplest concept, but it generally requires a lot of groundwork. You need to be able to show that you started using the mark before the filing date of the earlier registration, the one that's turned up by the examiner in their objection. And also the continuous aspect of this is crucial. It's not enough to show that you started using a trademark in 1973 and then just not provide us anything after that. It needs to go up to your filing date effectively. Honest concurrent use is a kind of a way of coexistence of two similar marks. It often comes up when there's a couple of, say, localized businesses using the mark for an extended period with no knowledge of each other at other opposite ends of the country or something. In this case, in terms of your evidence, as well as showing you've used your mark for a significant period, the honesty aspect of the evidence is really crucial. A strong way of showing us that you were honest in adopting and using your mark is to show the efforts that you went to clear the mark before you used it, which I mentioned in the previous section. Keep a hold of those searches if you can, and the dates they're performed, or just some record around the work you did at the time. Other circumstances, I'll be really brief here. It's really broad ranging. Much of it goes beyond trademark use particularly, and beyond the scope of this talk, but it'll require proof of something else. I know that's really vague. If you're really interested, you can go and read our examiner's manual, or there's an article written by a couple of barristers that borrowed from the Potbellies song "Don't Hold Back." You could search that as well. But really, the current law appears to permit evidence of use of the trademark after the filing date to supplement arguments made under the other circs ground. I'll move on to opposition now. I hope I haven't lost everyone. As an applicant for registration, you may be one of the lucky few whose application is opposed by a third party. Our figures, vary between about 1% and 2% of accepted trademarks get opposed. There are a few things that are really important to remember in this setting. So our role changes. You can't call up the opposition section and go, how can I overcome this opposition? We sit back as a neutral sort of decision maker, almost like a court. Effectively, we are a specialist tribunal in this area. So in order to be fair to both parties, we have to be, a bit hands off. We also find that quite a lot of people end up getting lawyers at this point, by the way, and it's really a trigger to think about whether you get a trademark attorney or lawyer. By the way, I would always recommend a specialist in trademarks. You can go to the family solicitor, but they won't know much about trademarks and they'll charge you just as much. So, okay. Because it's separate, if you relied on any evidence to get through examination, the evidence I was just talking about earlier, you will have to file it again if you want to rely on it in the opposition. The reason for this is, again, fairness. The other side needs to be able to see that evidence and critique it if they see fit. It's just about everyone having the same information and being able to make arguments about it. As the applicant for registration, you're playing defence. In legal terms, we say the other party, the opponent, bears the onus of establishing a reason why we should reject your trademark application. In some areas, a legitimate strategy is just to file nothing and maybe make submissions, poke holes in the opponent's case. However, sometimes there are assertions from the trademark from the opponent that you should really think about responding to in actual evidence, and that's where I'm kind of going to go next. The nature of the actual evidence will depend on what grounds of opposition are nominated by the opponent and how the opponent runs its case. So effectively, an applicant for a trademark in this situation is in a mostly reactive position. The same tips apply, however. Show us clearly what you've used, when, and where. I'll just move on to some practical aspects about all this evidence of use that actually showing us that you've used a trademark. I reckon some of the best evidence that you're going to have is day-to-day artifacts produced by your business. Things like invoices, marketing materials, website content that display the trademark in such a way that's connected to the goods and services that you offer. There are a few general things to keep in mind, however. You really want to, and I'll underline this, make use of the sign as a trademark. So it has to be presented in a way that it looks like you want consumers to recall it. Don't bury it in a sentence somewhere. Put it up in lights. Dates. The timing of trademark use is always, or almost always, extremely important. We basically look at a certain date and we go, right, we're not going to look at anything after that date, for example. So we need to know when things were, when things happened. So invoices would generally have dates on them, and physical marketing materials could, They could have a copyright notice or something, but if not, or like a 2002 catalog or something like that. But if not, there's often ways to sort of show like that there was a mail out to customers of it, or perhaps that the production of it with the marketing firm or something like that, with a graphic design firm. Those kinds of sort of materials can supplement the need for a date. Also, look, internet we find is probably the most fun, because web pages, they might have a copyright notice on them, but often they don't. So a really good tool here, and if you've got a pen, maybe write down www.archive.org. It's a free service that actually takes snapshots of web pages throughout time, and you can actually find, provided you haven't told it not to scrape your website, you can probably find past versions of it up there. Actually, while I'm on this, static evidence is the next thing anyway. We print that out. Don't send us a link to the Wayback Machine. Don't send us a link to your website. Send us a copy of it, because websites change over time. Like if we click on it today, it might be different to how it was a month ago. Okay. Area of use is important. Generally, we give a lot of weight to evidence in Australia. Sometimes we might take into account overseas use, but it's going to be weaker evidence, because again we are in we're talking about monopoly in Australia here. So okay, and what else? Oh, the form of the evidence. This is pretty straightforward. We've got a declaration form on our website. Try and follow it. There are instructions on the form, numbered paragraphs, that kind of thing. Fill out all of the fields that are marked with an asterisk because they're mandatory. Material that you can't put in writing in the declaration, like an invoice, for example, you should mention it, give it an annex number, and attach it to the back of the declaration. By the way, there are example declarations for for examination evidence sitting in the manual, the trademarks manual. Again, probably the easiest way is just to search for trademarks manual, IP Australia, and it should link you straight through to that. What's left? I think that's it for now. Rebecca, over to you.
Excellent. Some great tips there. Thanks, Adrian. Now, let's look at the potential consequences of not using your registered trademark. So in Australia, trademark registrations are vulnerable. Whoops, I was on the wrong slide there, sorry. Trademark registrations are vulnerable to removal after 3 years of non-use. Registrations can also be vulnerable to removal on the basis of the applicant's lack of intention in good faith to use or authorize the use of the trademark. This means that correct ownership is really crucial. If you have multiple entities and you file an application to register your trademark in the name of one entity, but the trademark is actually being used by a different one of your entities, you'll need to be able to demonstrate that the use is authorized use under the principles that I set out before. If not, you risk losing your registered trademark rights. So it's really important to get this right. Now, this is a brief overview of a non-use proceeding. This is filed with IP Australia. So in terms of the stages, it's kind of kicked off by a third party filing an application with IP Australia to remove your registration for non-use. Essentially what this is this third party is alleging that the trademark has not been used during the relevant period, or alternatively, or in addition to, the owner lacking an intention in good faith to use or authorize the use of the trademark. Now, the owner of the trademark must then file a notice of intention to oppose the removal application, followed by a statement of grounds and particulars. This will essentially summarize their use of the trademark or their arguments, or a kind of summary of their position of why the trademark should not be removed from the register. If these documents are not filed, so that's the notice of intention to oppose and the statement of grounds and particulars, then the removal application is not formally opposed by the registered owner and the trademark will be removed from the register. The third party then files a notice of intention to defend before the proceedings move into the evidence stages, which Adrian is going to discuss for us in more detail shortly. Once the evidence stages are complete, we reach the hearing stage, and this is where either party can request a hearing on the matter. Now, there are a few different options for the hearing format. So you can request a decision on the materials filed to date. You can request a decision or a hearing by way of written submissions only. And you can also request an oral hearing. An IP Australia hearing officer, such as Adrian or one of his team, will consider each party's position and evidence and will issue a decision. Now, depending on the outcome of the decision, the trademark registration will either be removed from the register or in some cases partially removed for some of the goods and services, but not others. Or alternatively, it might be allowed to remain entirely on the register. Decisions on non-use proceedings can be appealed within 21 days up to the federal court, but if no appeal is lodged, then the decision becomes final. Now, Adrian, I'll pass back to you to discuss the evidence in removal proceedings.
Thanks, Rebecca, for setting out the law and process. Recall earlier, much earlier, I mentioned that you kind of have a grace period of sorts for goods and services that you intend to offer, but not right away. This is where that period effectively runs out. It is dependent on a third party, though, filing an application for removal. So you may have you've got an indefinite grace period, but the minimum is usually around 3 years from when you got your mark up on the register. I'll put a little asterisk there. There's another provision, but I won't worry about it because it only affects trademarks that were registered before the 24th of February 2019. I don't know. Anyway, sorry, I'm prattling. The practical aspects of showing use still apply to opposing removal, of course. You got to show us copies of actual use of the mark, like invoices, marketing materials, that kind of thing. But there are kind of specific rules about defeating an application for removal. The first thing that really is important to remember is your role is reversed. As the owner of the mark or the person opposing removal, the onus now falls on you. You're not playing defence, you're playing offence. So you have to positively prove that you've used the mark, for example. Oh, by the way, there's another sort of aspect to this, and that use has to be in good faith. It's it sounds like someone's impugning your honour or something, but really all it means is the use needs to have been for a standard business purpose, that is deriving profit and goodwill. That's it. Okay. So it just needs to be proper use of a trademark for what it's meant to be used for. For that reason, you're playing offence. You can't sit back and poke holes in the other party's case. You're the one putting up the positive case. There are two grounds under which a party can seek removal for non-use. They're up there under the key evidence heading. I'm sorry for including the sections. I couldn't think of a pithy sort of way of describing each, so that's what we've got. Effectively, 92.4a is an allegation that you never intended to use the mark, or at the time of filing at least, you didn't intend to use the mark. So there's two ways to defeat it. The really simple way is to show you've used the mark, because that's obviously, you didn't just intend to, you did. The timing of that's important, though. It has to have been 1 month, at least 1 month before the application for removal of the trademark. But any time before, that's fine. The other thing, the other way you can defeat it is if you haven't used it. If you can't show you've used it, you can show intention to use. So, I mean, you could, for example, in that case, include copies of internal emails illustrative of work going into launching the brand, or external engagement with service providers such as signwriters or advertisers, that kind of thing. For 92.4b, what you need to do, you are put to, well, there's a few ways to defeat it, but the best way, the clearest way, is to show us use of the mark during And this is slightly complex, so bear with me. You start with the date of filing of the application for removal. You go back a month, just like you did with the other one. And then that's the end of the period. And then you go back 3 years. So during that 3 years, you've got to have shown use within that period. It is okay to show us just one instance of use. So it's not a really high bar to overcome to defeat a removal application. Generally speaking, we like, if it's going to be one instance of use, we want it to be pretty clearly shown. We want it to be fairly, I mean, the civil standard is balance of probabilities, but I mean, it's likely that a single use is going to be scrutinised a lot more than lots and lots of examples of use. And, you know, as decision makers, we look for shortcuts. So if we can find a really clear example of use, we're going to hone in on that. There are other ways of defeating an allegation under the 92(4)(b) ground, though. It's sufficient, for example, to show us evidence that you tried to use the mark, but it was somehow frustrated. We had a lot of this during COVID. One of the issues with those arguments during COVID was to say, well, COVID, you know, I can't use the mark. And that wasn't quite enough, if you know what I mean. Like, you kind of need to show how it impacted you personally or your business specifically, rather than just saying, hey, the whole world is in turmoil right now.
Yeah, you almost would need to demonstrate that, but for that event, you would have been in a position to be using the trademark, right?
Yeah, that's exactly it, and that's actually the test generally. So it's for whatever event you were alleging stopped you using the mark, right? The other one is, again, this is just a giant topic, so I will not get into it in detail. But you can try to convince the decision maker that even though you haven't used the mark and you weren't frustrated in using it, that it still would be a bad idea to take the mark off the register. Generally speaking, you've got a basic one of the big areas in which you can do this is to show that it would be somehow confusing if you removed it and let the other party get up, because again, I'm just going to limit myself. We can't talk about this in detail here, yeah, that's the end of our, I think, main presentation. And yeah, Rebecca, over to you.
Excellent. Thanks so much, Adrian. All right, so that concludes the main part of our webinar. You might find our publication useful. You can download our Trademark Essentials guide in the Resources tab on our website, or by scanning the QR code below. You might also be interested in our upcoming event. On the 26th of September, we are running a webinar on IP for in-house lawyers, protecting your organisation's assets. So we hope to see you there. We're also going to, so we'll be answering some of your questions shortly, but while you submit them, we'll take a minute to tell you about LegalVision's membership. Now, by becoming a LegalVision member, your business gets access to unlimited full team of 100 and more specialized lawyers for all of your business as usual legal needs. It's like having your own in-house counsel for a fraction of the cost. Our team can assist you with unlimited document drafting and reviewing of business contracts, unlimited legal advice consultations, and unlimited domestic trademark registrations, and heaps more. As a LegalVision member, you won't worry about the cost of lawyers ever again. Think about it as having your own in-house counsel. We'll take care of all of the business as usual legal work so you can focus on running your business. We also offer a dedicated service for our in-house teams and general counsel to manage your high volume business as usual legal tasks. Our lawyers invest upfront in understanding what's important to your business and we work as an extension of your in-house legal function. If you want to learn more about how membership or desk extension can help you, request a free consultation when the survey appears at the end of this webinar. Now, we also wanted to point out that IP Australia is a wealth of knowledge and information when it comes to IP rights in Australia. You can access a lot of educational resources such as IP case studies, FAQ videos, and on-demand webinars via IP Australia's website or by scanning the QR code in the webinar slide. I'd encourage you to have a look at these materials to further develop your knowledge and understanding. They're very useful. And now we will answer some of your questions. All right, so first question, one for you, Adrian. What steps should I take to maintain my trademark once it is registered? And are there any ongoing requirements or obligations for maintaining a trademark?
2, I think. And I'm happy for you to jump in, Rebecca, if I've missed any, but 2, you have to renew it every 10 years. I think you can renew up to 1 year ahead of that 10-year period. The reason we restrict it is because we do raise our fees every now and again, and it would be silly to allow someone to renew 200 years in advance. So that's the sort of legal formal requirement. And then the other one is, we've already discussed it, it's use the mark, and keep records of that use if you can. You will inadvertently anyway, because hopefully you're putting it on your business materials. But yeah, by use you protect it effectively.
Excellent, thank you.
Yeah, are you gonna? You'll
Anything
just
else
keep
to add on
reading
that?
No, you go. Thank you.
The only other thing I'd add on that is also it's important to keep your trademark registration details up to date. So if the ownership changes of address, contact details, things like that, you definitely wouldn't want a third party going and filing a application to remove your registration for non-use, but you don't even get notified of that because your address is out of date and it gets sent to the wrong place. So even those small kind of admin-y tasks can have some consequences. So good to stay on top of.
Rebecca, you've reminded me as well. Related to that is the way we communicate. If you're self-represented, keep your email address that you've nominated with us, well monitored. Check the junk mail, check the clutter, whatever, because we alert you to things through that. And for example, there could be a removal application filed, and if it's gone to your junk mail, you might not log into our website and see that letter. So yeah, please do keep a good close look on that nominated email address.
Really good point. Thanks, Adrian. Or better yet, you could appoint LegalVision to be your address for service, and we can manage all of that correspondence for you. Now, next question is how best to start the classification process of your trademark? This is a good question. And so the way that classification works, essentially, when you're applying to register a trademark, there are 45 classes of goods and services, and they're categorized into different groups under those classes. The first 1 to 34 classes are goods or products, and then classes 35 to 45 are services. So when you are looking at filing a trademark application, one of the most important things you're going to look at is the scope of your application, and that's where do your goods and services fall under those particular classes. IP Australia has a pick list of goods and services available on their website that shows you a list of pre-approved terms, shows you how all the different areas are classified into different classes. So that can be a really good place to start. There was also a second part to this question. How do I develop an IP dashboard to see what my competitors are filing? That is also a really good question. So a lot of businesses will want to keep an eye on trademark applications that are being filed in their industry, or perhaps keep an eye on particular competitors to see what kind of action they're taking, what they're filing in terms of trademark applications. Are they expanding into kind of different product areas with their trademark applications? You can kind of garner a lot of information from the trademarks database. LegalVision's fantastic IT team has actually developed a platform that our members have access to, where you can set up monitoring for third-party applications, and that can be a really good way to gather that intel for your business to make sure you become aware of any applications that you might want to oppose as well. So we'd be more than happy to give you a run through of that if you book in for the free consultation at the end of the webinar. All right, one for you, Adrian. Is it enough to register a trademark in just one class? Does that also prevent someone else registering the same trademark in other classes with IP Australia?
I love this question.
A good one.
It is. So yeah, technically, yeah, it's fine. There's no requirement that you look for every possible class. In fact, it'll cost you more money to file that way. Every possible class that your goods might be described in. Look for the best one and describe them clearly. Once they're there, it will actually prevent someone registering the same sort of text, or it can, if it's got the same meaning or similar. Look, there are some. I'll just throw out, because we think about this in-house quite a bit, and the courts talk about this a lot as well. So very recently, we had some decision that decided that, for example, the word coffee doesn't just mean beans or desiccated sort of granules. It also means the drink, and the drink falls in a different class to the beans. So the courts are on board with that idea, but there has to be a limit to it as well. For example, if I specify nuts in a food class, I'm not protected for nuts in a metals class, right? They're different things. So there's a little bit of work to be done, I think, in the courts around this. But in general, yeah, you're covered for the goods that you've applied for, no matter which class someone else tries to slip those goods in under.
Great, thank you. Next question. I'm interested to know on the most cost-effective ways to add a trademark for the United States. I already have one in Australia. Now, when you're looking at international trademark protection, you have two options really for filing internationally. You can either file direct national applications in the countries of interest to you, and to do that, that process will involve engaging an attorney or a lawyer acting in that country to be your local representative and to file the application with the relevant trademarks office there. The other option is to file a Madrid Protocol application. Now, the Madrid Protocol is an international system of registering trademarks. It is not one single international trademark registration, which is quite a common misconception, but it's more of a streamlined process of being able to file in multiple applications in multiple countries at the same time under the same kind of umbrella registration. Some of the benefits of the Madrid Protocol are that we can file them directly via IP Australia and through to the World Intellectual Property Organization. So your Australian lawyers or attorneys can file them on your behalf. It also streamlines maintenance, renewal, assignment, all the kind of downstream things that might happen in terms of maintaining a trademark registration. But it will really probably come down to a question of cost with the Madrid Protocol. The cost efficiencies really come into play when you're filing in multiple countries at the same time. So if you were only planning on going into the US, that might just be the more cost-effective option for you. We'd be happy to help out with more detail on that if you want to follow up with us after the webinar. Okay, one for you, Adrian. This attendee wanted to know about asset transfers from a sole trader to a company.
Thanks, Rebecca. I suspect, I mean, you probably know more about this than me. I'm digging back into my sort of law degree here, but I mean, we deal with assignments in IP Australia, so we see evidence of this all the time. Generally speaking, you transfer a trademark the same way you transfer any property. The two big ways to effect it in law are through a contract of sale or a deed of assignment. We do, as an office, accept evidence of evidence that there is evidence of an assignment through something we call a letter of assignment, and you'll find that on the assignment request form that we provide on our website. So there's no special rules about transferring from a sole trader to a company. You've just need to make sure it's clear who's selling the thing and who's buying it. So name the company properly, proprietary limited. You can stick the ACN on as well, just to be really, really safe, but it's not a requirement. And the individual that owns it needs to match who we currently have on the register of trademarks.
Excellent, thank you. The other thing I'll add there is just bear in mind that it's really a two-step process. So you need to effect the assignment by way of one of the documents that Adrian touched on, but people often forget that second step of making sure you notify IP Australia of the change in ownership so that your registration can be updated on the register. Okay, next question. This is a two-part question. The first part is, what capacity is there to enforce a trademark registered in Australia against overseas operators using the same name in Australia? Now, if a party is making unauthorised use of your registered trademark in the Australian market, you can take action against them regardless of whether they are an Australian entity, an overseas entity, an overseas individual. So we're really looking at not where that entity is based, but where the trading is happening. So if they're trading in the Australian marketplace, then you would be protected by your registered trademark in Australia. The second part of this question is, are there any time limitations on enforcing rights under a trademark against other operators using that trademarked name? This is a really good question, and there's kind of two parts to the answer to this. The first one is that there is a limitation period for trademark infringement claims, which is 6 years from the beginning of the infringing use. But second to that, you also want to take swift action, not just to get in within that limitation period, but also to make sure that that third party isn't accruing concurrent use rights. Like we talked about before, how a party can achieve registration or acceptance of an application despite a similar mark if they've adopted it honestly and been making concurrent use of it. So if you let that go on too long, that third party may have valid grounds to try and secure acceptance of their application. So that's something else to bear in mind. It's always best to take swift action, and especially in the early days before they get too committed to the name. If you notice that as soon as they're using it, they might put up less of a fight and be more willing to rebrand, for example, if you contact them in those very early days and nip it in the bud. Anything to add there, Adrian?
Look, really, I mean, I saw that because this was on notice, I got to research it, and there's one thing I'd add, and it's really minor. So the limitation period's not set in the Trademarks Act. We may legislate there one day, but we haven't at the moment, and so it's actually a state-based or territory-based law. And Northern Territory is the standout. They've got a 3-year limitation period.
Oh, I didn't know that.
Yeah.
Interesting. Thank you. I think that is all the time that we have questions for today. If we did not answer your question, please submit your details in the survey at the end. We are more than happy to give you assistance with any questions that we didn't get a chance to answer today. And we can also tell you more about how our membership can help you and your business. And while this is a free webinar, we really value your feedback. So if you could take a minute to complete the survey at the end, we would be very grateful. It shouldn't take more than 30 seconds. We really appreciate you joining us today and look forward to seeing you at future webinars. And thanks so much again for joining us, Adrian. Really appreciate it.
Thanks, Rebecca. It's been a treat. Thank you.